All right. Good evening, everyone. At this time, I'd like to call the meeting to order. Today is Thursday, August 28th, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche peoples. I will now lead us in the saying of the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Secretary, may we have a roll call, please?
Commissioner Bass.
Aye. Here.
Commissioner Copeland. Here. Commissioner Kirby's.
Here.
Commissioner McCafferty.
Here.
Commissioner Topshin.
Here.
Vice Chair Goldman.
Here.
Chair Rory.
Aye, here as well. We have a quorum. At this point, we'll move on to the approval of the agenda. We have two appeals on the agenda for tonight.
I'll move to approve as presented.
Second.
Okay, we'll do a voice vote on this. All in favor, please say aye.
Aye.
Any opposed? None. That motion carries 7-1. And now we will do the minutes. I'm going to give everyone a chance to read those because they were a little more substantive.
Motion to approve. Second.
Okay, a motion and a second. Oh, please.
There's one just typo, and the editor in me can't let it go. So where it says number 5 down here, it says just the approval. It says motion by Chair Rory, and then it says seconded by Vice Chair Rory.
Worthy of an amendment. With that amendment, I would move.
What name should replace it?
I'm trying to remember. Maybe it was me. If you said Vice Chair. Okay, thank you. Editor brain. I can't turn it off.
With that modification, I make a motion to approve.
Okay. All in favor, please say aye.
Aye.
Opposed? None? Okay, that carries as well. So we've approved our agenda, we've approved our minutes, and now we can move on to public comment for tonight's meeting. And I do not believe we have any speakers.
Not at this time.
Not at this time. So we will move on to our manager's report. Ms. Avalos, would you please lead us in a report?
Yes, good evening. Gloria Vilas, Rent Stabilization Supervisor, Acting Rent Stabilization Manager. Good evening, Honorable Commissioners. For our look-ahead calendar, tonight we will hear two appeals. The first one being case D5015 and D5029. Staff will also be presenting the increase to the valuation guidelines, the annual increase, and also the announcement of the interest rate on security deposits. For our September 11th meeting, we do have two appeals scheduled for that. That would be D case 4989 on remand and D case 4905 CD3. That's it.
Thank you, Ms. Aviles. Do we have any questions from the commissioners? I'm not seeing any at the moment. So we can now move on to the appeal portion of our agenda. And tonight we were going to do the first appeal, which is D-5015. And we're going to hear from Council first to give a brief overview, and then we're going to have the representative for the appellant come forward and talk after Council gives us a preview.
Thank you, Chair. My name is Kellen Martz, Legal Counsel to the Rent Stabilization Commission. This first appeal is D-5015. Property address is 1041 North Stanley Avenue, Unit Number 3. The appeal tonight is filed by the tenant, and the issue tonight is the hearing examiner's decision to deny the tenant's rent decrease application related to Regulation Section 6005A4. The tenant filed the application while an appeal was still pending and did not declare an exception under the rules. When the D4988 prior case became final on June 2nd, the filing remained within the 6-month period referenced in the regulations. The hearing examiner found that the tenant did not declare or demonstrate that any exception to the rules applied. Because the application did not meet the requirements of that section, the hearing examiner did not review or decide the matter on the merits. The tenant has lived in this unit since 1983, and tenant filed this rent decrease application in March of 2025. I'll refer you to the staff report for the numerous issues that were claimed in that application. It looks like there were 9 of those. And then on appeal, the tenant reiterated some of the claims but did not provide argument or evidence regarding the actual appeal arguments. Tenant has claimed that the determination is in error and is not reasonably supported by the findings or evidence in the record. And the question before you tonight is there substantial evidence in the record reasonably supporting the hearing examiner's determination to bar the tenant's application on procedural grounds? Staff believes that there is substantial evidence in the record to support that decision and that the decision is not in error. Staff agrees with the interpretation of the hearing examiner. Not in your staff report, I have a little bit of a supplemental explanation. These both are very complex. I'm sure going through them, they're not your standard, look at washer dryer type of cases. It's a lot of dates and a lot of math and a lot of going back and forth between numerous decisions. So I'll try to provide a little more clarity and then we can go from there. So in this matter, the examiner denied the application under Regulation 6005A4 because by the time the decision was issued in this case on June 25th, 2025, there was a prior final decision in D-4988. The hearing examiner in D4988 issued the decision on March 27th, 2025, and that decision was appealed, but the tenant withdrew the appeal on June 2nd, 2025. That triggers the matter becoming a final decision, June 2nd, 2025. Under Regulation Section 60036, withdrawal of the appeal makes the decision final as of June 2nd. Because there was now a prior final decision in effect, the hearing examiner, when they were writing their decision in late June of 2025, had to use that fact in their analysis. The tenant in the application had not declared or demonstrated an exception on the application form as to why these issues were not addressed in D4988. The regulation is designed to prevent repetitive filings that relitigate the same issues and consume additional staff time and commission resources when they could have been applied for together. The process allows and prefers that all issues are brought together in one application and requires them, if they wish to file again within 6 months of a decision, to explain why the new application has grounds that could not have been raised before. Here, that step was not taken and the application was procedurally barred. I understand how this is a little bit confusing and complicated. The overlap between the 6-month rule and when a decision becomes final has some complexities and gray areas there. And we are always open to regulation updates that can improve this process. I also just want to note how uncommon this is. I haven't seen it in the 8 years I've been around this commission. Lastly, under Regulation 60029A4, as noted, an appeal will not be accepted if it fails to state any facts or arguments supporting the grounds alleged. This requirement exists for the same reason we limit duplicative initial filings. Without specific issues or explanations on appeal, staff has little to review for the staff reports and the commission is forced to relitigate and review the same claims already decided by the hearing examiner without additional explanation. Lengthy, but that concludes my report. Thank you, Chair.
Thank you. I think we might have a few questions. I see Commissioner Topchin.
Yeah, thank you, Chair. Good evening, Mr. Martz.
Good evening.
A couple of questions. Can you explain what are the exceptions under the section 60005A4?
Yes.
Or what would be the applicable or acceptable exceptions for this particular scenario?
Yes, of course. Let me pull that open. Sorry, I apologize. It's 60005.
Correct.
A4, not 60054.
No, I said 60005.
A4? Okay.
Yeah.
So an application will not be accepted for filing, so the initial application, unless the following apply, 1, 2, 3, and then 4 is within 6 months, where less than 6 months have elapsed since a previous final decision. And so you have to explain the exceptions if it's been 6 months since a final decision has been made. The June 2nd date is the key date here. The withdrawal of 4988's appeal takes the case from pending status, where it's not final, into final. So the finality happened when they withdrew their appeal, June 2nd, and so that's within 6 months of this whole matter. And so when the hearing examiner is writing his or her decision, I would assume the week of the 25th, because the date, if it was finalized, is the 25th, they're now looking at the fact that there is a final decision. And so that's kind of the key distinction. So it's a procedural kind of gray area. Again, this is why I say I haven't seen this in 8 years, but the spirit of the regulations are to prevent duplicative filings. And here, some of these issues in this case and the other could have been filed, or all of them, in the previous case, 4988, and they weren't. And if there is a reason they came up later, or there's a few reasons that are exceptions, they have to state that in their application, and that didn't happen in this case.
What are the
So the-
exceptions?
Yeah, I was going to say the tenant had to state some sort of reasons
Yes.
why the tenant refiled, and these are not explained, but what are the exceptions?
Yes, it's. I don't know if you all grew up in the same time I did. The chapter books that if you wanted to go to the blue door, you turn to a certain page. That's kind of how this is we're at one regulation, and then we have to relate back to another one. So we will go to that. I will find the actual number in a moment,
Okay.
but you have to state why the issue you're bringing in the second application could not have been brought forth in the initial application. So, for example, if one was filed on January 1st and the next was filed on February 1st, let's say all the issues started December 1st, then they all need to be filed January 1st. The rule, though, is there could be an exception, such as these things happen on January 2nd. But we don't presume those, and the regulations and the RSO don't presume to know the dates. If it is within the 6 months of the prior filing, it needs to have the exception box marked and explained.
I see.
The tenants in the next case did do that, but not in this case.
So to follow up on that, the application for D4988, the reason for filing is maximum allowable rent. That's the only reason that was checked. So I have only first page. I don't have all other remaining 4 pages. I don't know what was listed in that application, but I see the date 11/15/2024, and only maximum allowable rent box is checked. When you look at the application, the subsequent one, D5015, filed on March 3rd, 2025, the maintenance check, the reason for filing is maintenance. Seems to me like two different reasons.
That's actually the reason for the rule. They could have gone together because the date that the issue was filed in 4988, those issues, and this is where we can't presume. So if it's filed within 6 months of the 11/15, then they have to say why was it not filed with the other case? So it doesn't matter if it was a different issue. So again, the spirit of the rule is we don't want multiple filings. in
Interesting.
in an extreme case, if we didn't have these safeguards, you could file a rent reduction case every day of the week, and for 30 days. So and if, again, extreme case, that actually could be legal under our rules, but you would have to explain the exception. And without explaining the exception, you don't get the benefit of the multiple filings.
Thank you for explaining that.
Sure.
That's interesting. So new things I'm kind of learning, because you're right. We didn't have anything like this before. So, but in my opinion, in my mind, that since these are two completely different issues, maintenance and the maximum allowable rent, given what you explained. So, I am on 11/15/2024, they had an issue with the MAR determination, but then in March 2025, there was a maintenance issue. So to me, it's like two different things, and could have filed differently on different dates.
The code doesn't allow that.
Okay, interesting. Okay.
The code allows that if you explain that there's an exception that applies.
Okay.
And that was lacking here. So again, you don't get the presumption as a tenant. You have to explain it to us, because we're trying to prevent multiple filings. And so if you're going to file multiple times within 6 months, you just have to explain why. It could be that something happened around Christmas, which is after the filing of that original case. That's an exception. And then that would have allowed 5015 to apply, and said, hey, my washer broke on Christmas. I couldn't have filed it unless we can go back in time, and we can't yet. So, but lacking that exception being explained, the procedural bar is there.
And the exception box, it's on the application somewhere?
That we can look at, I don't know.
The actual,
Yeah,
check box for exception or something.
That I don't know. I will look at that.
Do you have anything further?
No, thank you,
Commissioner?
Chair. Thank
Okay,
you.
great.
Not at this time, and thank you, Mr. Martz, for
Of course.
explaining.
I know we have other commissioners who had questions. I'm going to turn to Commissioner Bass at this time.
Yeah, I can wait for Mr. Martz to find that if you need the time.
No, let's go through those. I'm not a great multitasker, so let's
Okay,
do some questions. here
that's
and
why I
then-
didn't want to throw a question at you while you were looking for something.
Nope, I'm not
So-
looking yet.
So thank you. Can you explain to me a maximum allowable rent application, which is 4988? That's the only issue that was in 4988, correct?
Yes, I believe
Okay.
you were right. Yes.
From what we saw, that's the only thing that was in 4988, the one that precludes 5015, which is before us right now. How is a maximum allowable rent application a request for a rent adjustment? As I understand it, a maximum allowable rent doesn't ask for any rent to be adjusted at all. It simply asks for an impartial third party, the hearing examiner, to make a determination about the existing rent. Or am I misunderstanding that? Or the maximum allowable rent application, does it ask for a rent adjustment at all?
It could have a rent adjustment if the landlord does not pay the lump sum and an overcharge has been calculated. The tenant can then deduct a portion of their rent until that lump sum is fully paid.
Is that a rent adjustment or just a refund of overcharges?
It's a refund of overcharges, but it affects the amount of rent that they're paying.
But it does not affect the maximum allowable rent, which would actually be a rent adjustment, right? Or am I misunderstanding? This is where I'm hung up.
I think the regulations use that term generously, rent adjustment application, but I will look at that question deeper.
Because that's where I'm going with this, is because in regulation 6005A4 subsection C, in 4 there are 4 exceptions that allow you to file within 6 months. You can state the grounds on which you couldn't have had the information before, these sorts of things. But C specifically says rent adjustments were not sought in the prior application in relation to the particular units in question. So I'm asking, if it was only a maximum allowable rent in 4099, were they asking for a rent adjustment or just a determination of the MAR? They weren't asking for the rent to be changed just to identify what the actual correct amount was?
Just what I've seen as far as these types of MAR decisions, the rent adjustment is, for example, if the tenant is paying $1,450 now, and somehow with the MAR determination, it was determined that the calculations were added illegally, like they didn't use the correct amount, then the MAR would go back to the base rent, which is the rent that they were paying when they first moved into the unit, until they comply with the requirements of if an overcharge was required or was decided on, or if this was because of re-registration was not on file. So they go back to the base rent once the landlord pays the lump sum or the tenant deducts that from their rent if the lump sum isn't paid, and they file for a rent re-registration form if that's applicable to that case, then it's adjusted again to what they used to pay prior to the hearing. So there is an adjustment to the rent through a MAR.
I'm hung up on that because I did a MAR adjustment, and the math turned out that my landlord was overcharging me 2 cents a month. I mean, big deal. And so that's just my rent now. It's not that they changed my rent. The hearing examiner just determined that the math was done wrong, very minimally. And so obviously it's really easy when it's $2 a month to make a lump sum. It was all solved very quickly, but I guess I'm just hung up on it's not an adjustment of the rent, it's just a calculation of what is the actual rent, is it not?
Correct, but I'll refer you back to what I just said. I think that term is used liberally, so it applies to MAR, rent adjustment, and hearing examiner matters. And I was doing some research while the two of you were talking, and so yes, I believe what I've said is correct based on further research. So our regulations say a rent adjustment application is filed to, I'm paraphrasing, effectuate Municipal Code 1744. If you go to 1744, it includes all of the different topics that you hear tonight, or not, you hear MAR, rent adjustments, and housing service and maintenance issues.
So in this regulation, there must have been something under consideration when they said that you could have an exception if there was rent adjustments were not sought in the prior application. So what type of hearing could somebody apply for at the rent stabilization counter? What kind of hearing before a hearing examiner could they file that does not seek a rent adjustment if a MAR is included in that description?
Which of the regulations are you specifically?
6005 4C is the exception. It says rent adjustments were not sought.
I believe you have to read the whole sentence. Rent adjustments were not sought in the prior application in relation to this particular unit in question in the current application. So I think...
Okay. In the current application.
I think this is speaking more to maybe a common area matter where there's multiple common areas being involved. And so you could say the exception is I couldn't have filed on the previous date of the filing because I didn't file it. And those issues that were discussed in our common area application were not my specific unit.
The phrase current application actually makes a big difference there. Thank you.
Sure.
The next question I have for you is basically the entirety of section 60006, incomplete applications. So in this case, the hearing examiner in their decision specifically said it's on, if any of you want to look, item number 6 on page 29 of our packets. It says D5015 did not comply with the 6-month moratorium of final resolution prior to the filing of the new application. I'm going to emphasize this part, it's important. And the applicant did not declare on the application that 6-month filing limitation should not apply in the application. So that was part of the decision, but the incomplete application says within 10 business days of the date of the acceptance for filing of an application for rent adjustment, the hearing examiner shall determine whether the application is complete, which in the decision they're saying it wasn't complete, and there's a whole process where the hearing examiner is supposed to then notify them that they are deficient in their application, meaning they didn't say why there was an exception, is how I'm reading this, and correct me if I'm wrong, please. But the hearing examiner is supposed to let them know and give them 60 days to then provide that information. And if not, then it's considered that the application was withdrawn. It does not appear in the hearing that any of that happened, but that rather the hearing was just denied. The hearing went forward and then the application was denied. Am I missing anything there?
So in your explanation or question there, you said 60006.
60,006?
60,006, yeah. Where it says incomplete application, the hearing examiner is supposed to review it and let the applicant know. So I'm wondering if that was missed
No,
here.
I get that part of it. I'm just trying to find where you're
Okay.
at. So page 29.
29, item 6 is where the hearing examiner says that it was missing.
Okay, so I got it. He didn't cite to 60006. He
No.
just
I
wrote
just
it
kept
down.
reading after I was reading 60005.
Yeah, so first is another procedural issue. If you don't raise an issue on appeal, you waive it, and so that would apply here. That issue would have to have been raised by the tenants in their appeal application. So I think that's the major hurdle here. And then in the actual regulation, it could. I don't know.
Why don't you, I think maybe, have you looked at 6006?
Yeah, I have
Give
it
you
right here.
a second to look that over, because I think it's a valid point, and maybe
So
look
yeah,
at it.
I see what it says here. I think there's two issues. One, the procedural bar, I think is just, what it is. You have to raise these issues on appeal, and I know it's hyper technical, but that's how, in the real courts and in the baby court that we have here, same thing. If you don't raise issues on appeal, you waive them, just like if it was a housing service and there's 10 and you only bring up 5 in your appeal, you can't talk about the other 5. You've waived those. Same thing with procedural issues. Excuse me. The second part is that from the hearing examiner's decision and how staff agrees with, there's 2 issues why this matter fails. The one that you speak to is if you think that the hearing examiner should have done that, that's one. But the 6-month bar is a separate issue. That is not a requirement under this rule to say you missed filling or explaining the exceptions. This rule is like if actual check boxes are not marked. Let's say they got an application and it had none of the MAR, rent reduction, and housing service check boxes checked. That's what it's speaking to, but that would veer into giving legal advice. Hey, there's a regulation or a municipal code section that says you need to explain the exceptions. You didn't do that, please do that. That goes far beyond, I think, what 60006B says.
Only one, and I promise I'll move on, because it's really, like you preface this, it's a very complicated case, so I want to make sure I'm reading the regulations correctly. Is there any, I'm losing the word, but the entire 60005 talks about the acceptance for filing, and it implies, in my reading of it, that the city will not accept an application unless these things are. So that's where I got to, is the application complete? Could the city actually accept this because these exceptions are not expressed? So that's why I'm trying to get around that. Like, the city accepted this, the hearing examiner accepted it as complete, and yet then says, but you didn't include this.
Again,
It's not a matter of evidence, I don't think. It's not a...
That's going into, and if staff called me and said on that, I think that would veer into legal advice and go beyond what, and we have discussions about what staff, how thorough of a review when this comes in, should they just kind of rubber stamp it and push it on or whatnot? And I think we're getting to the place where no, there should be a little bit of a initial review, but not to the point where we're looking at the regulations and saying you missed this, please provide it, because that's getting into the substance of.
But I want to push back just a little bit, and that's because it says here, it's not made on the form, it's not all this is 60005. If it's not on the right form, if it doesn't have the payment or the waiver, And so it lists things that in that exact same section that the same section as you need to mention the exception, 60005, that the city does review. So why are we reviewing? If somebody walked in with just a plain piece of paper and saw on the form, the city would say, sorry, we're not accepting that. It's in the exact same section, so why would we not also say, oh, and by the way, this is also part of 6005, like the form, like the payment, but you didn't do that one? Why are we only giving advice on those other two and not this one? It's why I'm having a hard time getting past that.
Yeah, it veers into, I think, legal advice. The review of what staff should be doing is kind of the clear-cut things. Does it have the application? Did they pay the filing fee? Some of the issues that, I think have been missed in the past are things like an application's filled out, they've checked housing service, they give us some photos and nothing else. You're required to explain the issue. Or vice versa, they say washing machine. And we see this on appeals too. They say, I appeal. I'm being extreme, but you're required to explain these things. That's where potentially staff could, if it's that black and white, then I think there's an opportunity for staff to step in. But where there needs to be some analysis, like is happening here, I think that veers into giving legal advice or going way beyond what staff is expected to do at that initial stage. Because, and again, I would argue that these issues have to be raised on appeal. This one wasn't, and I know that's a tough, kind of stance, but there are, however, how many pages of regulations, we can't put them all out there.
Right. It's because it's an exact same section as the others that we would enforce, and I'm not suggesting the staff say, oh, this is a good excuse or that's a bad excuse. Like that, to me, feels like it would definitely be legal advice. But is there an excuse or not? To me, it feels like it's more of a checkbox situation. I'm sorry. But
That's okay. I think it's a good conversation. I want to move on to the other questions, and then we can do deliberations and things like that. I'm going to ping pong back to this side of the dais. Commissioner Copeland or Goldman, did you have any further questions? Commissioner Kerpes or Carol?
Thank you.
Yes.
So kind of on the same lines, we have a situation here tonight where a full hearing was held. Both sides gave testimony, and it was only after the fact that when he was writing when the hearing examiner was writing the decision that they came to the conclusion that it didn't qualify or basically wasn't going to deal with the issues. So my first question is, how do we get to that situation? Like, why doesn't does the process not allow for the hearing examiner to have known about that issue and it only came up later? And then my second question is, what are our options here tonight if we were to, some of the common things we do is we remand, we deny, we affirm. So I understand what happens if we affirm the hearing examiner's decision. If we were to waive a 6-month, would that what effect would that have? Kind of just give us some options that we might want to consider.
Yeah, so for the first part of your question, yes, there have been a few cases recently where these half-baked or problematic issues have come up and we're kind of left months later, why has this gotten here? Valid question. So we have 3 new hearing examiners on contract starting September 1st. So that are new people that we can train and kind of discuss some of the intricacies of rent stabilization work, because it is hyper-technical. I would note, on this type of case that we're looking at, again, this is the first time in my 8 years, and I think Commissioner Topshin, you said, you've been here longer than me, and this is new to you. So while it is a problem, it's not a regularly occurring thing. So that's a good thing, that our regulations are good, just maybe not perfect. So we have new people starting. We're working with staff on kind of fine-tuning what things, management and legal think they should be looking for, because there has been a practice kind of I think, for the applications that come in, and as long as they paid their money and filled out the form and signed it, that it would make it to the next step. And I think just with staffing resources and commissioners' time and, city taxpayer money, I think we agree that there should be a little bit of a filter at the beginnings, because we don't want these cases getting along if they could have been fixed in the beginning and everyone gets their decisions quicker. So we're working on that in the background, and that's part of the training we'll be doing with the new commissioners, the new hearing examiners. The second part is the options tonight. So I think the commission, rightfully so, has remanded a fair amount recently. I think most of the decisions we should be making here without remand, that should be the exception, not the rule. And sometimes the exceptions get lumped together, and we've seen a few of those recently. My recommendation on both of these are very clear procedural issues that, again, don't feel super fair, but sometimes that's life. I did kind of ponder, that exact question. I do think it would be entirely appropriate in this case. And again, I'm not a fan of waiving the 6 month very often. Again, that's an exception, not a rule. I think this is the exception. Because these issues were not decided on the merits, they were decided on a procedural ground. If you waive the 6 month, let's say in both, the tenant could refile those, and I don't want to look at further dates, but I don't want to do the 6 months based on tomorrow filing. But if 6 months says it hasn't, because it was June 2nd, so they could file tomorrow, and then, not giving legal advice, but generic tenant would want to potentially say the explanation of why they're filing within the 6 month window.
Okay.
And I guess the last question about that is, so it's just at this point, there's no way we can recoup the fact that there's already been a hearing. That's just going to be, depending on what the commission does tonight, but that essentially would just go away, like it never happened. Or could they apply evidence could they submit the previous hearing examiners?
You can submit whatever you want. So
Okay.
yes, absolutely. Because the previous hearing examiner's decisions are still valid city documents. They don't poof disappear because you decide there was a procedural problem.
Okay. Thank you.
Commissioner Goldman? Vice Chair Goldman?
I'm glad I had my Wheaties today.
So we really got into the weeds here, and so I just want to try to ask a direct question of you and see if that clarifies for me and hopefully for others. So when we're looking at the rent decrease application and it has this 6 month filing limitation, what we're looking for is, were we looking for the tenant to check, they have all of these circumstances, to check the boxes of one of those circumstances and then explain that? Is that what essentially we were looking for from
On the
them?
initial application,
Yeah.
let me look at one. Apologies. Okay, I have the 5015 open. So they would have to explain in their explanation, just a separate piece of paper, the exception to the 6 month rule.
So I don't know if you, so you see how there's just the check boxes there? You probably can't see it from here,
What
but
does it say? Sorry.
so it says, because it actually has check boxes here, it says, unless applicant declares and demonstrates that one of the following circumstances applies, and then it has circumstances that it looks like you can check off. So I'm wondering, are we looking for them to do that and then
Got it.
provide further explanation?
Farther down in the, yes. Hypotheticals are hard because if it comes up and I say different, you're going to say, oh, but
Yeah.
because it also, I'm reviewing what the hearing examiner did. However, I would think if one of those was checked off, it would be a very good basis for the hearing examiner to accept it and say they met that requirement. If I was a hearing examiner and I saw one of those checked off, then I would dive into that during the hearing and explore it. A perfect application would check that and then attach a sheet explaining why, but the regulations don't say you need to go into extreme detail. So, you know, procedural rules are like the minimum threshold. You know, if you do the bare minimum and I would say that would be the bare minimum, you can always exceed it. But I would think, and I would have chats with staff what they think offline, but yes.
Okay, because what I was wanting to get at is because if there's nothing to that effect, then that means that we're tied to, they're not following that regulation.
Right.
Okay, yeah, I just wanted to clarify. Thank you.
I have one question before we go to round twos.
Quick one.
For the dates that we're talking about, if we adopt staff's recommendation, the 6-month rule would be triggered off of the June 2nd withdrawal. So the tenant in this instance wouldn't be able to refile until December 2nd, 2025. Is that what the current resolution would trigger?
Yes, as written.
Okay, and then Commissioner Topshin, and then we need to move into
That was my question.
good.
Thank you, Chair.
I
Okay,
think Commissioner Kirby's asked, could you waive that? And I said, this would be
and
the
they can be,
exception to that
that could
rule.
be adjusted.
That I think would-
Only about the date. Because 40988, for whatever the number is, the first one, 4098 or whatever it was, I have to look at my notes, but you know what I'm talking about.
Yes,
That one's not before us tonight.
Correct.
But that's the one that controls on the 6 months. Could we waive in the resolution tonight the 6 months, even though that particular one is not before us?
yes, you would waive the 6-month refiling on this, which would allow the tenant to file tomorrow instead of wait 6 months from now.
I just didn't know if that other
It-
one's still controlled on the
It
6 months.
doesn't waive the requirement to explain the exception to the rule. So they would still need to check that box or submit a backup page explaining why one of those exceptions listed on the application and in the regulations applies to this case.
Thank you.
Okay. Well, I think that was helpful because this is a very procedurally intensive appeal. So I appreciate, Ms. Bella, you listening in on all that and everyone at home. But we're now going to move on to the testimony part of the appeal. And we do have a representative for the tenant tonight. I'm told it's Ms. Bella, and she's the tenant's daughter. So what's going to happen is you're going to have a chance now to come forward to the podium, get yourself situated, pull that mic nice and close so we can hear. And you're going to have 5 minutes to divide as you time. Is the landlord registered at this point?
They're not present.
Okay, so unless something happens in the next 5 minutes, you're going to have a whole 5 minutes to talk, and there probably isn't going to be a landlord to speak, so you can just have your 5 minutes. And there are 2 appeals tonight, so try to stick to the issues in this particular appeal. And state your name and city of residence, and then your 5 minutes can begin. Thank you for
evening.
waiting.
Now?
Yes.
Okay, I'm at loss because whatever was said here, I kind of understood, but not all of it. The whole ordeal started when the landlord became a new landlord, 22, I think, like 3 years ago. I don't even know where to begin. When I went to the city hall and I filed and I brought all the pictures with what's going on outside the apartment in next to the trash, floods and everything. So they told me this separate apartment, whatever's happening, my dad is 90 years old and he lived there half of his life, 43 years. So that's separate. The paint is separate. The wall gas heater is separate. That's why I filed so many times. Because every time I would go to City Hall, they would tell me, no, that's the wrong one, fill this one out. I would fill this one out. They said, it cannot be put together. It has to be separate. Then the landlord overcharged. I think you have all the copies and all the pictures. I spent, it's a 30-pound bag that I tried to put together. So the landlord sent this piece of paper stating, giving my dad a 3-day notice to either pay full rent or move out. And on February 23rd, 2024, I think, I provided a proof of canceled check from Bank of America that the total amount was $296 and the landlord put down $236. So when I spoke about that to the commissioner, he never answered how to get this money back. Do I deduct it from the rent or the landlord will send a separate check? So that's one issue. The other issue is the gas wall heater. He's not going to repair it. My dad, as I said, 90. He has low hemoglobin and iron. He's constantly cold. I bought 2 battery that you plug in to keep him warm, and the light bill went 3 times as much. That's another issue. A third issue is that the landlord last year, almost exactly last year, in September, well, actually in August, he gave 30 days. He sent the letter to my dad, not the letter, I'm sorry, emails, stating that since my dad is not driving anymore, so he's going to remove the 2 parking spots in the garage, which was originally in a lease agreement in 1983. And he offered $50. So I sent him an email asking, is it per spot or how do you calculate that? I also asked the commissioner, right? The other guy is also commissioner, twice. He never answered that either. How much are the space? Is it 1 space? Is it 2? So when I deducted $50 as the landlord offered, he sent 3-day notice that if you don't pay the full amount, I'm gonna move you out. Even though my dad, 90, Holocaust survivor, and lives there for 43 years. Sorry.
It's okay. Take your time.
So I don't know how to get his money back. And the commissioner never answered. And because first time they told me, the people who work at City Hall, they told me you have to file everything separately. You need to find out how much is the rent because he increased the rent in he bought the building in 21, 22, and there was supposed to be a frozen rent. So they said, this is separate. Then you have to find out how much is the rent. So they guided me what to write and what to fill out. And then when he denied, and I said, but he denied everything which is in black and white. I have proof. How do I get $60 back from March of 23? How do I get the $50 he promised off of the, and when at the last hearing, I told, there was his secretary, Stephanie, and I said, okay, then let me have the parking space back because my dad has doctors and nurses and physical therapists, and I come, to give him medicine and everything, and the street has no parking. It's pretty bad. And it's an open, one of those old buildings that it's an open garage, one parking behind the other. He said, no. I'm not going to give you back the space, and I'm not going to take off the $50 that I promised. So it's exactly a year. That's another $600-700. I mean, my dad is receiving $1,300 a month SSI. And so I don't know. Am I too much? I'm
No, it's
jumping.
okay.
So as of right now, I have 3 issues. To fix the wall heater, so when this winter comes and my dad is alive, I want him to be warm. How do I get back the $60 as of 2023, March? And how do I get the $50 that he promised per 1 spot, and there are 2 spots?
That's your
And
time.
everything else, they even came to see the apartment, and the gas company put a red tag, and the landlord came, he saw the papers, he took the pictures, he saw the red tag, and since March 18th, I think, of this year, he said that he's going to send he has a guy, Wilbur, I think is his name. He is the electrician and the dentist, and he does everything.
That's fine.
And I said, this is dangerous because it was leaking. My dad was coughing a lot, and you could smell.
Ms.
Well, we
Spiller,
have
that's your
to,
time.
Oh, you have all that?
we have to pause, yeah.
Okay.
But I appreciate you coming down. No, you did great. If you could please stay there, there might be some questions for the commission.
Chair, do you mind if I just ask a quick procedural question?
Sure.
Hi there. You said there were 3 issues that you are concerned about: the wall heater, the parking issue. I missed the second one in writing my
The
notes.
$60, which Should I show you the paper?
No, I'm just
He
writing
knows.
for my notes
He knows.
for later.
Because
Yes.
the orig-
No,
Just a
ma'am,
sec.
just.
I just
have
had to
him
write
ask a
this
question.
down. I have to give it back to them. I'm just a observer. So they're in
Bec-
charge.
Because when you were talking about MAR, whatever, they told me that whatever is outside the building, that's why the other two tenants came in with me.
Okay.
And I didn't ask for rent decrease, but I just brought this so that the landlord does something. It's impossible to live like that.
That's fine.
It's a 10-unit
I have
building.
to stop you, I apologize, just at this point, to be procedurally fair for the whole process.
Sure.
But there might be some other questions.
Oh.
Commissioner Copeland?
I just wanted to, it's my understanding that the parking issue is for the second case. It was not for the second hearing, is that correct?
That issue is addressed in the second.
In the
hearing,
second
yes.
one, not this one. So my question is, you mentioned a wall heater, and was there, if you don't mind refreshing my memory, was there a code compliance report on that was included, correct?
The gas company put a red tag. The landlord came over and saw it. He asked the whatever these people that do licensed. A gentleman came over and wrote whatever is wrong, the way it's built. This building is built probably in 1940, so it's not up to date. And that was it. Nobody came after March. Nobody did anything. While it's summer, so I'm not pushing it, but I don't know how else to handle it.
Okay, thank you very much.
Thank you.
Thank you, Chair.
Commissioner Topchin?
Commissioner Copeland, you asked about the inspection by the city, right?
Yeah, code compliance.
Code compliance.
inspection, yes.
Good evening, Ms.
evening.
Bella. So a question, was there any, because your father is a Section 8 tenant recipient, was there annual inspections by the Section 8?
While during COVID, like for 3 years, they didn't come over. They just renewed without rent increase because it was frozen by City Hall. But he still increased it 3 times. That's a separate issue. I don't care anymore. I'm fed up with all this. But with the heater, the Section 8 did not come yet.
But did you reach out to them? I just
Yes,
wondered.
yes,
Okay.
I did. It's impossible to reach them. I have another 10 pounds of fax that is always busy and email
Okay.
that are never answered.
Yeah, the reason why I asked, because I saw an inspection report from 2022. I wonder if there was something newer, fresher.
Yeah.
Okay, but thank you.
Thank you.
I'm going to turn to this side of the dais. Are we okay on questions? All right, Ms. Bell, I appreciate your time. You can go ahead and have a seat,
Okay,
and we're going to now do the deliberation portion, and you can,
okay. And also can
I'm sorry,
One
no,
second.
I'm not allowed to allow further testimony.
Because Airbnb people
No, I
get-
appreciate, but I apologize. It's, no, it's okay. Stick around and watch the deliberation. There's the second appeal, as you know, so. Okay, so we're going to close, no public comments on this item, none. Okay, so we're going to close the testimony portion. And we have a lot to unpack here, obviously. I'm going to kick off the discussions by saying that based on the evidence in the record, which we're allowed to consider, and excluding anything beyond the scope of this appeal or testimony-wise that was not in the record was troubling about the extent of the issues that were being talked about. And I know there's procedure, and I'm a huge procedure person. I think I probably have said that on multiple occasions during my tenure on this commission, and it's part of my legal training that procedure really matters. And it's a process. It is a pre-thought out process with policy reasons about why procedure is important and why rules have to be followed. And there's a saying in law school and in life that says, bad facts make bad law. And what that saying basically translates to is extreme facts can reveal flaws in the law or a policy, where you've got a fact pattern that is just, no one's ever heard of it or seen it in 8 years, and all of a sudden it results in a legal conclusion that is following the process and following the rules, but boy, it doesn't feel right, to use an expression that was sent tonight. So I don't really feel that this is a situation that we should just strictly follow process. I think this is one of the examples and rare occasions where it's okay to deviate from process. And I would be amenable to shortening the time for the tenant to file another application based on whatever issues that were appropriate. And if there's a requirement that they have to check a certain box on the form in order to have that application heard, that we make every effort to make sure that it be done, including follow-up if that's necessary in light of these facts. And I'm going to kick it over to the fellow commissioners at this point, but and that's my very 100,000-foot level overall on this one. And I'm going to ping pong right, because I ping ponged left the first time. And maybe I'm going to ask Commissioner McCafferty if you wouldn't mind.
Yeah, the big sticking point with me is this application form. The application will not be accepted within 6 months, blah, blah, blah. To me, that states that this application should have never been accepted, and that is a clerical error that staff made. It's not, punitive of staff or anything. Like, you guys are busy and things fall through, but so because of that, this shouldn't have been accepted, and so I'm happy to waive the 6 month at the very least. What strengthens that is, like the merit versus procedural. Like, you don't want to, like the merit in the spirit of this entire appeal. I'm not comfortable with just sending it home based on a procedural error. So that's where I'm at.
Thank you, Commissioner. I'm going to jump to this side. With any takers, I'm going to ask Vice Chair if she wouldn't mind giving her thoughts.
So I'm with both of you in that same thinking there. And I also heard in testimony, she mentioned that in speaking to somebody there, she maybe thought that she had to file things separately. So I'm wondering if there's, I guess, anything else that can be done to get information to people so that they understand correctly. But I'm usually on the side of, yeah, we've got to follow the procedures as well, but this one does feel kind of rough in light of all of the information that we have here.
Commissioner Kerpes.
So I agree with what's been said earlier this evening. This is, it's difficult how this is turned out. I agree with the hearing examiner's decision that this should not have been, or that this can't be considered. I would hope, and this is a request that I have of staff, that it's Ms. Spraga, right? Spraga? She's taking care of her 93-year-old father. I'm sorry, 90, okay.
Don't age him up there.
I have a mom that's taking care of a 101-year-old great aunt, so I understand the stress and the amount of time that takes. And to fill out applications like this is very complicated. This isn't your full-time job or your primary focus. This isn't her residence that she's living in and having to deal with every day. She's doing this on behalf of her father. I would hope that staff could tomorrow or set up a time with her to, if it can't be our city staff, then maybe with Betzedek. Yeah, I was going to say, I can't think of her name right now, but yeah, thank you. That somebody can sit down with her one-on-one and take kind of what we've talked about tonight. Staff can maybe fill them in, look over the issues so that an application, because she's done great on the application that she submitted. I mean, she provided evidence, she listed it out. The hearing sounded like it went fairly well. But there's this procedural issue. So I will be supporting the hearing examiner's decision, but I will want to waive the 6-month refiling so that they can file an appeal with the I guess it wouldn't be filing an appeal. Would it be filing an appeal or would it be filing?
Original
No.
application.
The original application, and explaining why it's within the 6 months of the previous application. So hopefully somebody can help her with that. And that's where I'm at.
Ping pong back to Commissioner Topchin.
Thank you, Chair. I agree with most of the comments made by the commissioners. You know, these are type of cases when we say our hands are tied because of the procedures that everybody must follow, right? So whether there is improvement to the procedures, of course, every rules, regulations, laws, they will have some flaws there, and you know, things definitely, you know, probably not definitely, but things may be improved if the commission looks into that, or staff or legal counsel look into that and recommend something, some changes, so then this type of things never happen again. As the legal counsel mentioned that we haven't seen this. I cannot recall anything similar to this situation, this kind of a scenario that we are having before us tonight. So hopefully things will be changed or fixed or improved so that we don't have this ever again. But I have, you know, first, I definitely, my empathy is with the tenant and the issues that the tenant is fighting. It's just, I don't think this should have been even there. I mean, because we live in West Hollywood, and every time when there is an opportunity, I always mention that we have very high standards in the city, and there are very tough rules and regulations. And if somebody wants to be a landlord in West Hollywood, they need to realize, so there are very strict rules and regulations they have to abide by. So they cannot just not fix things or take away services, or so these things may not be tolerated, and at one point the landlord will be penalized for this type of behavior. But this is generally speaking not in regards to your specific landlord. As for this particular hearing, I will have no choice but to support the staff's recommendation for the reasons I mentioned, because our hands are tied and this is a very strict procedural issue. As legal counsel satisfied the questions that I had in my mind, and I appreciate that. Now I feel more confident that you know, I have to affirm the recommendation. The one thing, though, is regarding the waiving. You know, I'm typically in favor of that, but I would definitely, again, we cannot make recommendation to the parties, but my concern is if we waive the 6 months period, and if the tenant files the new application, and let's say the explanation is not to the satisfaction or expectation of the hearing examiner or whoever is reviewing the application, we will end up in the same situation. So that's what I don't know how to deal with it. So then if we waive that 6 month period, we cannot tell the tenant, hey, go seek legal help with that application, because we are not in that situation to recommend anything like that. But what I'm saying is that if we waive that 6 month period, we just want to make sure that the application will meet the expectation of that body that is going to review and accept, and then we don't have to come back again and say, oh, you know what, that application is, you know, whatever we call it, is not going to be reviewed or granted or honored. So anyways, but I'm in favor of the 6 month waiving if the commission is leaning towards that conclusion. Thank you, Chair.
I just wanted to provide Commissioner Topshin a clarification on the concern. The application does say, as an option that the hearing examiner, commission, or court of competent jurisdiction has explicitly stated in the prior decision that the frequency of filing limitation shall not apply to the applicant. So if you guys decide tonight that they will waive the 6-month fee, she can check off this as the option. So it wouldn't come back to you as she didn't provide a good explanation or exception.
And besides checking one of these boxes, would that tenant be required to provide their explanation in writing? That was my understanding from what the legal counsel explained. If there will be another sheet with the explanation, so that's the explanation part, I don't want that be rejected.
So, again, hypotheticals are hard. So, my interpretation is that the problem is that's not actually a checkbox. It is a instruction sheet. So there's a little bit, we can tweak that. But that's the bare minimum in my mind. I am not the hearing examiner. I don't know where they will take that. But if it came to me on a staff report time to write that up, I would probably have a different interpretation than I have tonight.
Thank you, Mr. Willis and Mr. Martz.
Commissioner Bass.
I echo the sentiments of my colleagues. I appreciate the robust conversation. I specifically want to thank you, Mr. Martz, for going down that road with me and having that conversation. I'm usually a rules person, but so I'll echo what the chair has said here. And it brings me back to the regulations, and it specifically, you know, in my questions I asked about 60005A4C, as the exception being rent adjustments were, and I was told I had to read the whole sentence, and it says in the current application at the end of the sentence, but it says rent adjustments were not sought in the prior application, so no rent adjustments were sought in the prior application. In my opinion, the MAR is not a rent adjustment. In relation to the units in question in the current application. So in the current application, it's this unit. Was that unit subject to a rent adjustment request in the prior application? And my finding is no, it wasn't. So there is that exception. And so my preference would be that rather than us affirming the hearing examiner's decision and waiving, which I think we should waive if that's the direction the commission goes. I think that what we should do is reverse on the very technical grounds that the tenant met that exception and the hearing examiner made an incorrect call on that particular exception. So reverse on that and remand for a hearing on the underlying issues that were presented in this case. That being said, the reason I think that's important is that this was filed in March. If the tenant files tomorrow, any rent adjustment that the hearing examiner may or may not find is applicable would go into effect as of tomorrow and not March. And I believe in this case, although 60006, where the hearing examiner was supposed to let the tenant know, hey, you didn't check this box, and they didn't do that, that's not before us. I don't think that we should penalize the tenant that staff didn't say, hey, you didn't check one of these boxes. The hearing examiner, by regulation, was supposed to tell them that they didn't check that box. And they get all the way to us when we say, hey, if you would have checked that box, we might be in a different situation. But you don't get a rent reduction because we failed to remind you twice that you were supposed to check that box. So I would like, if my colleagues, if there's anyone that's on board with me on that, I'd like to make a motion, see where that goes. Not before everyone speaks. I'd like to hear everyone speak first, but I'd like to make a motion to that effect and see if it goes anywhere, and then maybe consider the alternative that's been discussed if that motion doesn't go anywhere. That's where I'm at. And thank you all.
Chair, if I may briefly, I want to clarify a few things. Some things I'm going to say are not debatable opinions. The interpretation of what a rent adjustment application is and how that term works is one of those. That's a legal determination. And so I would strenuously recommend that we don't go down the route that you just stated, because the interpretation of what the municipal code is and the regulations, some of those, you have a lot of discretion about what you decide, but what is a rent adjustment application and whether MAR falls under that, I think I was very clear that the code says that. And so the regulations are a little bit softer, but what the code says is what the code says. And so my strong recommendation is we don't go down that route. And two, I think I was very clear that this was not a staff mistake. And so I recommend we avoid that. That is legal analysis of whether the exception applies or not. That is not what staff has been instructed to do. And as the attorney, I would explicitly tell them not to do that. So this is not a staff mistake. Sometimes these things are just things that happen, but this was not a staff mistake. So
I just, first of all, I want to be very clear. We have an incredible staff, so I don't want to in any way imply anything negative there at all. But you know, we all have a sense that we're in a really sticky, kind of gross situation right where we're at tonight. I think that's where I'm coming from on that. And then I just want to ask legal counsel, where does our de novo opportunity come in if it's not to interpret regulations?
de novo, there are opportunities. I can write you a memo on that. I can't spit it out right now. But you asked a good question. The distinction there is certain things are what the law is, but how that law applies to certain facts, I think, is where you have it. But when it's the procedural issues, those aren't de novo type of things for the most part. I'm happy to write a memo on that, but I don't think de novo would apply in this situation.
Thank you.
Commissioner Copeland.
Thank you, Chair. As stated earlier, this is quite a robust discussion that we've had, and surprisingly for me, I actually have more comment and questions for the second hearing. But normally, I feel the same way. Procedure is procedure, and you know it's spelled out very clearly. And if there's a mistake in the procedure, but there have been occasions where we have made an exception. And if this is how my fellow commissioners feel like we should make the exception for the 6 months, I don't have a problem going along with that for all of the reasons stated earlier in this case. Thank you, Chair.
Okay. Okay. Go ahead, Commissioner Carice.
So we talked about different scenarios that options we have for this. I know it doesn't make sense to remand it because the hearing examiner has already made their determination based upon the law. But what if we were to remand it and open it up to allow for the tenant to make the argument of the exception?
The requirement for the exception is part of the appeal, or the application. So it's supposed to be done when you apply,
Supposed to be, yeah.
Not at the hearing. There's not really a process for that. And my recommendation is this has...
Actually, let's back up. You just said that it happens before that. So that's staff making the decision whether an exception applies? Or the hearing examiner making an exception?
The hearing examiner does. But they're supposed to apply with the exception, then it gets to the hearing examiner and they review whether that exception meets their burden, the hearing examiner's burden, in their decision.
So I'm asking if we were to remand it, but require that hearing be opened up for that discussion on the...
It's supposed to be in their original application. That's the issue. And since this one has such a kind of messy procedural history, I think the better route is that it starts from scratch. I know it's a little bit slower, but then a better application can be filed with potentially the assistance of staff, BETZETIC, CES, and they will also have the benefit of whatever resolution you vote on, but I have a draft of where this is going, the waiving of the 6 months, and the explicit finding of the commission that 6-month rule doesn't apply. I personally think that's a better piece of evidence to submit than a remand with the record that is kind of messy in this case.
Okay. Any other comments? All right. Again, a robust discussion. In the spirit of allowing Commissioner Bass and maybe some others to make his motion, and in light of the legal counsel comments, I'm going to give you that opportunity to make your motion and then see how it goes. And then if not, I'm going to move to affirm and waive the 6 months.
I will simply say that I would actually be really interested in even if it's just a private conversation, understanding where our de novo, maybe it can be a part of a study session or something, but understanding that, because if it's not interpreting the regulations, I don't really know what it would be, but we're specifically given that authority. But I will heed legal counsel's advice on that and not make the motion. But I would say, Commissioner Kirpies, I like the direction you were going, and if that was the direction you wanted to go, I would go down that road.
Okay, so if you want to make a motion on...
I want to comment on what we've been discussing. I'm not ready to make a motion unless I'm forced to. I will if I'm forced to, but I really want to comment on the discussion that we're having.
Oh, you wanted around 3? Okay.
Yeah, I mean, I don't know about round 3, but yeah, I do want to talk about what we have been discussing, because I do have a problem. I can't, to me, it's very clear that this was, the procedure is very clear, and that the hearing examiner made a proper decision in this, and I can't justify, I like your argument about whether the law applies or the exception should have been made or not, but what gets me is it's still the responsibility of on the appeal, it's still the responsibility of the tenant to make that, at least suggest it, and there was just nothing here to where I don't agree with us putting facts on the table or making, putting logic together that would exclude that. But I think that one of the ways, and I'm not sure if I fully understand what the negative effect of it would be, but I think that the way I personally can get around that issue is that if we were to remand it, both sides have the opportunity to argue whether the exception is legit or not, why they should or shouldn't be able to file it within 6 months, and that would take care of most of the issues here. I believe it would go back to the original date of the application. So that's where I'm at.
Well, do you want to make a motion to that effect then? Because I think we have more comments on this side.
We have more
apparently,
comments. Yeah,
Okay.
before we entertain a motion, or
was
if
gonna say, I
there's a
can make the
motion, we'd
motion
like
and
to
not vote, yeah.
have a comments after the motion made for.
No, let's do comments before. I thought we had kind of straw polled on reverse and remand
Okay.
or affirm and waive, but let's go ahead and do the comments.
Thank you, Chair. I'll try to be very quick. So I appreciate the commissioners, Commissioner Bass and Commissioner Kirpis, exploring the other, opportunities, whether remand or a reverse. I strongly disagree with either of these options for the reasons explained very well by the legal counsel. I had questions myself. I had my doubts myself, especially when I saw the application from the 4988. I said that there's a disconnect, and obviously the next application was also somewhere there. So the legal counsel was able to clearly explain and sort out all the things that we were confused with all the questions that we had. I don't know how. Was there any better way to explain? I doubt. I don't think so. So at least to me, everything was clearly stated. And when I make a comment in regards to whether there was a mistake by the staff, I don't believe so. I am not persuaded that the staff made an error by not telling the tenant how to navigate through this application or what needs to be put there or what needs to be checked there. I don't believe there is a requirement for staff to do so. So this is an application, and we don't know who accepted the application at the counter. It could be someone who has very little knowledge of the RSO or no knowledge of the RSO accepts the application. The job is just to accept the application and file it. So I don't believe that this is staff's error in any way. That's number one. And the reason why I don't believe we should remand or reverse. And the second reason is that we have to go by the code, and we have no choice but any other kind of a reasoning not to go by the code. Regulation is sort of a softer, as legal counsel mentioned, interpretation of the code. But if it comes to the legal, obviously as the lawyer yourself, Chair, if it comes to the legal interpretation, you have to go by the code, right? You're not going to go by the bulletin that was printed and available at the counter or by some other document. So if it comes to that point, the code matters. So, and I think after what I heard from the council and from everybody else here, so the issue is, to me, very simple. Procedural, whether the procedure was followed. Although there's a lot of confusing facts, I don't believe the procedure was followed as it required. So that's why I think we should affirm the staff's recommendation, and we can waive the 6-month period. Thank you.
Vice Chair, I know you.
Yeah, so thinking about if we did remand, we would be in the same position. Is legal counsel correct? Because it needed to be in the initial filing. So if we remanded, then it would probably end up in the same place. I just want to make sure that I'm correct in that.
Yes.
Yeah, okay. And so Commissioner Topchain did say a lot of what I was thinking, which is that once legal counsel explained, it makes sense. And I think that affirming and then waiving that 6 months, I think that's a good compromise where we're following the procedure, but also being sensitive to the situation.
Commissioner Copeland, do you have anything more?
No, I completely agree with what Vice Chair suggested, that it seems to be the cleanest, maybe perhaps legal compromise here to do, is to allow a new application, but waive the 6 months rather than trying to remand this. So I would agree with the Vice Chair. Thank you.
And Commissioner McCafferty?
Yeah, still at waiving the 6 months and affirming, but I like adding the language for the commission to explicitly state that the frequency of filing limitation shouldn't apply. I like that a lot.
So I'm going to turn it over to Commissioner Kirby. If you want to make your motion, I don't want to, and make a record of it, like this is your opportunity. I think you see where the direction is going.
Yeah, I'll make the motion, and I'm going to speak on my motion, even though we've already run around and around, but we'll make it brief. So I move that we reverse the hearing examiner's decision and remand this back to the hearing examiner to open the record to to determine, so both sides can submit evidence and determine whether an exception applies in this case. And that'd be my motion, and then I would like to speak on it.
Okay, is there a second?
I'll second.
Okay.
And the reason I'm still making that motion is because first of all, I disagree with that it has to be on the application prior to. Just like in a court of law, they talk about who has standing, does the court have jurisdiction over this? That's all made by the judge. That's the same thing here. I'm not blaming staff for what has occurred tonight. If anyone's to blame, it's the hearing examiner for not deciding at the very beginning, do I have jurisdiction over this? Does the person in front of me have the right to file the petition that they're filing? And that didn't happen, or happened very late, too late. So we've got basically a break in the justice system. Everything happened here. Both sides have given their arguments on, providing the arguments for and against, and for the rent decrease application. We've gone through the entire process. I don't think it's just to make them start all over again when it harms the tenant, as it was pointed out earlier. We can't make up for that. The only way we can make up for that time that has been going on since March 2nd is if we were to allow this to go back and give the hearing examiner the opportunity to determine whether an exception exists, which there clearly is. It doesn't take much to argue that an exception exists. It's a whole different issue. There's no history of back and forth of harassing the landlord with these applications. There's tons of, and we've already directed staff, and they've seemed to have agreed that they will sit down and talk with the tenant to help them fill out their application or to send them to a location that somebody can assist. We're not going to have this come back to us the same way it did. But that's why I'm pushing so hard for this. This is a way for us to correct what's happened to a 93-year-old man in our city of West Hollywood that doesn't have heat.
I'm going to close it at this point.
90, I was going to say.
I'm going to ask that we do, Madam Secretary, a roll call vote on this pending motion.
Commissioner Bass,
Aye.
Commissioner Copeland,
Aye.
Commissioner Kerpies,
Aye.
Commissioner McCafferty,
No.
Commissioner Topshin,
No.
Vice Chair Goldman,
No.
Chair Rory.
No. Okay. And that motion does not pass. So I think the direction and the consensus at this point would be to do the fallback motion. Council, would you lead us in a reading of that? But effectively, it would be to affirm and waive the 6-month rule with the additional language you mentioned to help make sure staff understands this is a strong direction from the commission that the 6-month rule is waived and the exceptions would not curtail further review of a new application effective immediately tomorrow, if
Yeah.
that was when they filed.
Happy to, and this is just a draft, so feel free to edit as needed. This would be the resolution that was presented to you to affirm with the addition of the following paragraph. The 6-month procedural limitation on filing a new rent adjustment application is waived, and the commission notes that the application may need to include in the, the tenant may need to include in their application that the commission has explicitly stated that the frequency of filing limitations shall not apply to the applicant. The commission makes such a finding with this resolution.
Okay, so that would be my motion. Is there a second?
I'll second.
Okay, Madam Secretary, may we have another roll call?
Commissioner Bass,
I want to say that I support the intent of this, but there are findings within the resolution that I've expressed tonight that I don't think I can find, and so just want my colleagues to know I appreciate what you're doing, but I can't make those findings, so I'm voting no.
Commissioner Copeland,
Aye.
Commissioner Kerpies,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Goldman,
Aye.
Chair Rory.
Aye. So that motion passes 6-1. And I know that Ms. Bella, you're going to be around for the second appeal, so you can sit tight, but we're going to take a quick break. And now that the motion has passed, if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And before we move on to the next appeal, I would like to do a quick recess. Let's give ourselves 10 minutes. It's 8:30. We'll come back at 8:40. Thank you. We're going to resume tonight's meeting of the Rent Stabilization Commission, and we're going to move on to item 8B, which is the appeal for D-5029. Same property as before, but a different appeal, different set of issues, and I'm going to turn it over to legal counsel to lead us in a overview.
Thank you very much. Again, my name is Kellen Martz, legal counsel to the Rent Stabilization Commission. This is D-5029. Property address is the same as before, 1041 North Stanley Avenue, unit number 3. The appeal tonight is filed by the tenant. And the issues are similar but different to make your lives that much easier. The tenant has lived at the unit since 1983. The hearing examiner found that the application was filed within 6 months of prior applications, D-4988 and D-5015, and when I go through the staff report, I have, again, a supplemental to explain some of these issues. That the tenant did not demonstrate that the exception applied regarding the 6-month filing limitation. Because the application did not meet the regulation requirements, the hearing examiner did not review or decide the tenant's claims regarding housing service reductions or MAR rent overcharge issues. Tenant's appeal does not dispute the procedural issues, but does reiterate the several issues, including the $50 per spot rent reduction for parking spaces, the gas wall heater that was red tagged by the gas company in March 2025, and a $60 rent reduction from February 2023 that the tenant claims was improper. The requirements prevent those issues from being reviewed both by the hearing examiner and by the commission on appeal. Staff recommends affirming the hearing examiner's decision. And this one is a little bit different. Here's the supplemental. In D-5029, the examiner denied the application under RS Rent Stabilization Regulation number 6005. The tenant filed this case on April 25th, 2025, while D-4988 was pending. On June 2nd, the tenant withdrew that appeal, which made that decision in 4988 final as of June 2nd, 2025. By that time, the hearing examiner was concluding its review, and they issued their decision on June 30th. Therefore, that was within 6 months of the finality of D-4988, which is virtually similar to the last case we heard. Although in this case, the tenant did state that the issues could not have been raised earlier, the hearing examiner found that they did not provide sufficient proof of that. The hearing examiner found, and staff concurs, that the record showed that the parking heater and the rent overcharge issues all predated D-4988 and D-5015, and those issues could have been filed in the earlier cases. Because no valid exception was established, the examiner denied the application as procedurally barred and did not reach the merits of the case. The same principles carry through at the appeal stage here. An appeal will not be accepted if it fails to state any facts or arguments supporting the grounds alleged. This requirement exists for the same reasons we limit duplicative initial filings. Without specific issues or explanations, staff has little to review, and the commission is forced to review the same claims already decided by the hearing examiner without additional explanation. And so for those reasons, staff believes that there's substantial evidence to support the hearing examiner's decision and recommends that the commission affirm that decision. And to get ahead of the question, staff would make the same comments that procedurally I'm against waiving in most cases, but this one I would not have an issue with that. And that concludes my report.
I think Commissioner Copeland might have a few questions, or at this time, do you want to wait?
Thank you, Chair. Appreciate it. Yes, I do have some questions for staff. In this case, in the original hearing, the determination that was D-4988 said that the maximum allowable rent for the tenant's portion of rent is $253 per the letter from the land, refers to the letter from the landlord that as of September 1st, the parking space allocated was going to be reclaimed, and this was going to give the tenant a $50 deduction. So that was a determination made by the hearing examiner. And then later in the packet, on page 97, the property owner's respondent said that the property owner offered to reduce the rent due to the removal of the parking spaces, but went on to say that she was informed by LACDA that the reduced rent should not be removed from the applicant's contribution to the rent. Due to the prohibition against side agreements, the respondent could not reduce the applicant's contribution to the rent by agreement. As such, the reduction was removed from the total rent, which reduced LACDA's monthly rent amount for the applicant's unit. However, the applicant's rent remained the same. So my question was, the side agreements for parking have been prohibited for at least several years that I can recall. So say hypothetically, if during the hearing, the examiner said, he reduced the MARD for the $50 it appears, when perhaps what should have been said maybe was side agreements are not legal in West Hollywood for parking, therefore give them back their space. And then the tenant would have gotten the spaces back and there would not be a reduction to LACDA. But so is that enough, if there were an error, say, in something like that in the determination or the legal advice that was given that's in contravention of the ordinance, is that enough of a reason for an exception or for a waiver of the 6-month period in itself?
I'll break it down differently. We'll probably get to the same place. But,
okay, great, thank you.
Of course. So that was in 4988. And so if that issue is not raised on appeal, it is waived. And so that's what happened. That is why the hearing examiner made that decision. That had already been reviewed, decided. The issue to the side agreements, during the break I was talking to the tenant a little bit, but only in broad terms because I don't want to prejudge anything.
Right.
There's two paths here. There's what the commission does and then what the RSD and city attorney's office can do that are not commission-based, things like looking at side agreements.
Okay.
You guys can look at them if they apply to the case and whatnot, but whether, there's a code violation by a landlord because of those things, that's, a little bit separate. But how this one, and even though the hearing examiner made that ruling in 4988, that's only as to kind of the MAR and the very limited scope of what the hearing examiner decides. Whether that is in violation of the municipal code is not decided by the hearing examiner. So we still have the ability as the city attorney in the city to review that separately.
To review that and then perhaps any correction that needed to be made, is that something the tenant would need to file any sort of separate application for, or what would the process be for that if it were to happen?
How we get to a resolution, I don't know yet.
Okay.
But
it's not something that we need to consider here for this
that
particular appeal, is what you're saying.
That is correct.
Okay.
And just to quickly, we have tenant harassment complaint forms. I'm going to recommend that we change the name of them because it sounds, they should just be like tenant complaint forms, because the word harassment, I've always thought it kind of, it sounds scary. I didn't feel harassed, but there needs to be a mechanism for someone to file about other things. That's administration.
Such as a
but maybe
possible
this,
error in a determination.
something that's not appropriate for the commission and is not technically harassment. There might be maybe a third form. I don't know. That's administration stuff. But that issue was already decided. It wasn't raised on appeal in 4988, so it's not before you tonight on that. But that doesn't mean that there's other things that we can't do for this at the city.
And the same thing, there's nothing prohibiting, say, in a situation like this where the tenant has had the service removed, but the reduction is actually going to a housing authority and not to the tenant. There's nothing prohibiting that from happening in the ordinance itself.
No, but there are oftentimes I disagree with how Section 8 administers their program, and that had that come to me, I think it would have resolved differently.
Okay, thank you so much. Appreciate you answering the questions. Thank you, Chair. That's it for me right now.
Thank you, Commissioner. I've been watching a lot of tennis, so I'm going to jump over to Commissioner Kirby's.
In your explanation just now, you mentioned 4998. I thought 4998 was simply the MAR determination.
4988, I think.
Or
But
4988, yeah.
I can pull it up, but either it should have been filed in 5015 or 4988.
I guess my real question is,
Are we talking about the parking?
yeah, that I thought this was part of 5029 on page 97 is where I'm seeing it, of our staff report, or of our packet. Seems to me it's in case D5029.
Let me get back to you real quick on that. Let me just look at some records here, if you don't mind.
Excuse me, if it does help, counsel, in the
Yes.
decision on D4988, under decision on part 3 is where it refers to that letter, if that makes any difference.
I don't have that open yet, but I think, Commissioner Copeland, I'll look to you to correct me if I'm wrong, but that it was a MAR issue on the parking because it was taken away. Is that how it was analyzed?
Excuse me, it says on number 3 under decision, the maximum allowable rent for the tenant's portion of rent is $253 per the letter from Mrs. Capital dated July 31st, 2024, which became effective September 1st, 2024. The landlord must follow all applicable rules, regulations, and ordinances before seeking to increase the tenant's portion of the rent. So it did refer to the letter that the landlord had sent about the parking space being removed and the compensation for it. So that's why I was asking about that, the way that I read it, but unless I'm incorrect.
Yes, that is correct. It was, and I actually have some emails from back in the day looking at this question because it's a MAR application, but the issue is that parking space and the $50 deduction. And so it had already been analyzed and decided in 4988, not as a housing service, but it was still reviewed and decided that it was, that the deduction had to go to, or was allowed to go to the Section 8 administrator as opposed to the tenant. And so that's what the 5029 hearing examiner found, is that this issue had already been decided, and so they made their finding that way.
Okay, that's why I was confused, because it seemed like after the fact that this seemed to mean that, okay, that's the tenant's portion of the paid rent, and then later the property owner or respondent said that they were informed later on that there were no side agreements, and therefore the tenant could not have that determination of the deduction, but it would go to the housing authority. So that's why I was a little confused between the hearing decision and then what we had in here. But thank you for clarifying that.
You're
sorry,
welcome.
Sorry for the time.
No,
Thank
no.
you, Chair.
That was helpful. Commissioner Kirby's, I don't know if you got your answer or you have other questions. You're good. Anything on this side? I'm going to ping pong. No? Okay. So with that, we can now move on to the testimony portion. Ms. Bella, this is your opportunity to speak on this appeal. And we haven't heard from the landlord, correct?
They're
Okay.
not present.
So you're going to get basically 5 minutes to speak. What I was going to ask for you to do on this appeal, if you could, there's 3 items that are kind of the focus of this appeal. So if you could try to limit your comments to those 3 items, that will help us in our deliberation. And my understanding, it's the parking issue, the heater issue, and the $60 overcharge issue. I hope I'm stating that correctly. And you'll have 5 minutes, and you may begin.
It's the same thing, yes, the $50. But when the hearing examiner saw me twice, it was the same gentleman, so he knew the first time when he said 253, second time he denied it, and I asked him, it's 2 parking spots, so is it $50 per spot, or who decides how much is a spot? It's the same thing as he would remove one of the bedrooms. I mean, am I clear? Making myself clear? So that was one side, the $50. Is it $50? Is it per one spot? To clarify that, he never did. hearing it twice, in March and June. And I originally filed in December, but I had medical issues, biopsies, so it was moved instead of January to March, and then from March to June. And they told me to one of the hearings, whatever, 498, they told me not to file it, not to proceed with it. I said, okay. So I said, but I have three issues. The $50, which is for a year, coming up in September. Is it for one spot or two spots? And how much is it? Maybe it's $30, maybe it's $70. I don't even know where he came up with this amount, but he should have probably looked into Section 8 before offering, because as Ms. Copeland, Chairman, as she said, it went towards Section 8. So the tenant lost his spot, and he didn't get his money, and Section 8 got the money. It's not their spot. And the second one, yeah, before the winter, for the licensed people from gas company, from, I don't know how they called, for professionals to come and do it's not repairs. It was done wrong originally in 1940s. So they said there is no way to repair it. It has to be. So they offered to the landlord when he was there to put AC in the window. So in the summer it's AC, and in the winter it's a heater. He said, don't give me any ideas, I know what I'm doing. And he said, I'm not gonna do any repairs because I don't want Section 8. As I said, it's a 10-unit building. There are 3 apartments with Section 8, my dad, another tenant who is 88, and another tenant who is a single mom. She's homeless now because he did not do the repairs. Section 8 came in 3 times, and they closed her program, voucher, whatever it's called. So he's clear that he wants my dad out. I don't know where I went with this. And then there are Airbnbs which have dogs and cats, and he said,
I want to
am
stay
I
on
going?
those issues.
Okay.
If you can keep talking, but just
Sorry.
on the issues. It's
There's
more
so many
helpful.
issues,
I
yeah.
understand.
So mainly, as of right now, mainly the $50 per spot. There are 2 spots, and it's been a year. $60, which was put in incorrectly. The check is for $296, but his accountant or whoever put it as $236, and they charged us again $60, but the bank cleared the check for $296. He got $296, but he still wants another $60 on top of that, which I paid. So I want the $60 back, and the gas heater to be done with professionals. And other issues, I am done.
Well,
there were 3 landlords in 43 years, no problems. This guy has his vision. He made out of 2 bedrooms, he made 3 bedrooms, he put extra toilet, it got flooded, I have pictures. I tried to do the code enforcement. They would not come out. It was flooding, so they came out, they gave him a citation. So I don't know where this goes.
well, those are other issues that you will have opportunity to pursue. And
I have no strength. I'm going through biopsy, I'm going through my stuff. But whatever is clear, whatever is on the paper, that's all I want for my dad to have back.
well, we appreciate you coming down tonight and speaking.
Thank you.
You did a really good job.
Thank you. And if you need an interpreter, I can volunteer.
Okay.
If you have Russian tenants, which City of West Hollywood is mostly Russian elderly people.
Sure, a good
So-
portion. Hang out. We might have a few questions
I
from the
would love to,
commissioners.
yeah, to clear them. Thank you.
No, Ms. Bella.
Stay here.
Yeah, Commissioner Topchin has a
Oh,
few questions for you.
Thank you, Chair. Thank you, Ms. Bella, for your testimony. Definitely it breaks my heart personally to see how you're crying, and your dad is 90 years old and dealing with all these things. It's just, it's wrong. So, but my question, there are a couple of checks here. They have different amounts, like for 292, 296, although this is from 2021. But why, you mentioned the 296, so how much is the rent now?
Per Section 8, it's 304. Per City Hall decision of the examiner, 253. Per landlord, 296. I don't know.
Okay, So, and you're paying,
253.
I mean, your father,
As the examiner put
253.
253. And so far, the landlord is not,
No issues with that.
I don't know
the-
what he's preparing.
And the decision of the examiner on the 253 was provided to the Section 8 office? Do you know?
I have no idea.
I mean,
Because
like the,
the rent, it's every April. So in April, they sent the rent increase from 303 to 304, but this decision was done in June after the Section 8, so I started paying 253. So I don't know if...
So
if
253, that is the reduced rent for...
For one parking
for parking, so one parking. That $50 reduction is, what you're saying is that the $50 reduction applied for one parking space.
That's what he
And you're-
offered.
What's the landlord offer? Okay, and that's what granted under this hearing, right?
I asked the examiner, I said, how does he come up with $50? Maybe it's 30, maybe it's 100. And
Okay.
there are two spots. Who makes a decision, how much, and, for two spots? He says, I'll look into it, but
But the decision
was denied.
But the decision was 253 in the hearings
the
decision.
first time,
Right.
in March.
Right.
In June, he says he's gonna look into it, and it's two spots, and he's gonna look into how much it is, because it depends on the street or building, or I don't know, and it
Okay.
was not clear. He didn't, I was hoping that he's gonna send a letter stating, deduct $60, which you already paid, deduct $50 for so many months, and that's it.
And you never got it.
But it
Okay.
was all denied, so I don't know how
It
to...
was denied, yeah. All right, thank you. Still, to me, it's still confusing.
Yeah.
What is the reduction clearly, and what is the rent should be, since we have like three. Okay, I go by the examiner's decision, it's 253. But I still wanted to hear from the commissioners any, regarding the parking. I'm totally confused. Thank you so
Well,
much. Thank you,
let's
ma'am.
conclude any questions for the witness at this point. I'm going to look this way. I'm not seeing anybody. Commissioner Copeland, maybe?
I just wanted to confirm, because in the record, it does state that the contribution that was going to the LACDA and not to the tenant. So is the tenant paying the 253, or is the discount going to the LACDA?
The tenant is paying 253, but the city, instead of 1494, they're putting 1454. I don't know how it works. Between the city of West Hollywood and LACDA, they can't find the compromise. They can't find what's the legal way to go about it. That's how I understand.
Okay, but he's paying less rent now than before?
$50 less
$50 less, currently?
currently.
Okay, thank you.
All right, Ms. Bella, thank you so much for answering our questions. We're going to do just as before. We're going to close this portion. There will be no more testimony, but you will have a chance to sit down and see us deliberate, and I apologize.
I know, I just want to make sure that it's since June. It's not since last September
Okay.
that we're paying 253.
Perfect. Okay.
If it makes, thank you.
No, I appreciate you clarifying. And now we're going to do the deliberation portion. And Commissioner Bass, could I ask you to possibly give us some preliminary thoughts?
I will say that most of my comments ditto from the last hearing, with the exception that now the commission has passed a resolution, and I find that binding on precedent, so I have no objections to affirming and taking staff's recommendation.
Okay. Commissioner Kerpes?
Yeah. So I'm still a little confused about why the hearing examiner would put in their decision under 5029 that the issues raised in D5029 could have been presented when application D4988 was filed. That implies to me that something wasn't in there, but could have been. Then I read under the decision, of the hearing examiner. Actually, not the decision. So I'm a little, I don't think this matters in the end. I mean, I'm going to support the hearing examiner's decision because I know how the last one went, although I do think this just emphasizes again that we had an opportunity to correct an injustice, and we're not. I'll just leave it at that. I'll support the hearing examiner's decision if that's what the commission wants to do, but I'm still a little confused about this parking issue. Why would the hearing examiner even entertain a conversation about the parking if it was already determined in the previous decision? And why would they separate it out like this and say they could have brought it up in the first application? Well, they did, according to staff. So that's what I'm
There
confused
was a
about.
question there. I don't know if you want to.
The hearing
maybe
so-
Riaski was.
So why is if one of the three issues in D50, whatever this one is, 5029, if there are four issues and one of them is really doing with the parking, yeah, in excess of the permanent, particularly rent increase during, no, that's not it. Oh, the number 3, provide established rent reduction offered to removal of the 2 parking spaces. So why wouldn't the hearing examiner say in this decision that that had already been decided?
I think there's multiple issues at stake here, or in discussion here, 3. The decision, I think, could have been written better, a little bit longer to avoid these questions, but some of the issues, such as the water heater, the hearing examiner says that arose prior to when 4988 was filed, and so it should have been brought up in that case. This one's a little bit harder because 5029 comes after 5015, so they could have technically filed it at that time, so it's kind of a double whammy. The issue, I think, how I interpret the hearing examiner's decision on this is that it was already decided. So not that you should have checked the exception box and explained why, but that issue had already been decided in 4988, that there was no issue with the parking being taken away. And then, I know I'm a broken record and it seems mean, but those issues have to be raised on appeal. They weren't, and so it kind of locks in that decision on the parking. However, there is a distinction I want to make there, and a potential amendment to the resolution if the commission votes that way. But the parking was only analyzed as a MAR issue, and because of that, the way you analyze MAR versus a housing service or a maintenance issue are very different, right? MAR is kind of math, spreadsheet type stuff. Housing service is a little bit more softy feely. Did it really affect your life? MAR doesn't ask those questions. So I think that there is the potential for them to file on the parking as a housing service issue. It was never analyzed by the city in that way, hearing examiner or anywhere, and so I also don't know where the $50 came from because parking in West Hollywood, even in our regulations, is not that. So that just goes to the statement I made that this was not analyzed as a housing service, because if the hearing examiner in 4988 had, they might have mentioned that our guidelines say the value of parking is X, $50, but they weren't analyzing it that way. So, and if you're wondering, it's about 80 to 300 and change for the range. So
I have a quick question. If we were to adopt the resolution tonight, just as currently written, is it the same December 2nd, 2025, that the tenant would be able to file an application for a rent reduction on the parking unless we adjust that December 2nd date?
Technically, no, because it is a completely different avenue. I would recommend that you would waive on that because I don't know what a hearing examiner would do. And we don't tell them what to do as like the city attorney or staff, but we do provide them a resolution. So if that was in there, that it would be clear your thought process on that. But
So you're saying we might not have to, but if we wanted to be extra clear that we think that parking could get reevaluated in terms of a loss of a housing service, that would be an appropriate modification.
yes.
Okay. Can I go to Commissioner Topchin?
Just to understand, well, I mean, I understood what you said, but just to kind of clarify, so the issue regarding the parking and the $50 or the reduction, so that was a MAR matter, not per se a reduction of service matter.
You've got it right, yes.
Okay, because if the examiner would have heard the parking matter, so that could have been a different value set.
Correct.
Okay, all right. So now that explains the other things that probably had in mind because, yeah, there are so many numbers here. So I would definitely be happy to modify the resolution to make sure that this can go back. Well, I mean, not go back, but can be heard again. Whether it's a waiver will be applicable, right? That's what you're suggesting, Mr.
Yes,
Martz? Yeah,
similar to
so
last
I
year.
would definitely will be happy to do that. Thank you.
Commissioner Copeland?
Just one more thing. In reviewing and listening to testimony, and I had mentioned just a hypothetical about if an examiner gives a decision that's in contravention of the ordinance, like side agreements. But listening to testimony and reading the packet, it appears, and looking at this letter, it's basically the landlord informing the tenant, effective September 1st, the parking space previously allocated to your unit will be reclaimed. It doesn't sound like there was, and according to testimony, it wasn't asked or agreed upon. It was confiscated.
Yes.
And it says parking space here, but then at the end there were 2 spaces that were confiscated or taken back. So is this something that you mentioned earlier that they could, because this was not a housing service removal type hearing, they could basically, if they wanted to, go tomorrow and request a hearing about the removal of the parking spaces?
Yes, that is correct.
But also it could be something that could be, as you mentioned earlier, an exception made to the 6-month or a remand, or so there are a few ways that it could go for the
That
tenant.
is absolutely correct, and also your interpretation of the facts and the testimony. Side agreement is a much more friendlier term than I think is accurate.
And it's
to what
prohibited
happened.
to, actually. But,
Correct.
okay, but reading the letter and hearing testimony, it feels that there was really not a choice in the matter. So that's a different scenario. Okay, thank you, counsel. Thank
You're
you, Chair.
welcome.
Commissioner McCafferty?
Yeah, I agreed towards a waiver of some sort, and then again, just like last time, an ask of staff to kind of sit down and sort this out with her, especially like the details of the parking and what, taking it from a place of a loss of service and just helping her walk through that, which isn't an official thing, but yeah.
Vice Chair.
I agree with my colleagues. I think it makes sense similar to last time. And then given that this could be filed as a loss of service, I think it makes sense to do it that way and then waive.
And I know Commissioner Topchin has a question. I want to ask one quick thing, though. Is the heater issue also something that could be raised as a loss of service item, or was that previously addressed as a MAR item? I just, because that seems, I'm
Yeah,
not sure where
so-
heater is in this.
The heater, the hearing examiner found, and staff agrees with, that that issue predates the filing date of 4988, and there was no explanation of why that wasn't filed with 4988 or 5015. And so that is a different analysis than MAR versus non-MAR. So no, they wouldn't be able to file on that
Unless we
under
waive.
under the parking, unless you waive, yes.
Okay, I'm just letting folks know I'm inclined to allow waiver on heater and parking. And I know Commissioner Topshin has a thought.
Just a question or recommendation, suggestion, whatever it is. If Ms. Bailey, if the tenant speaks Russian, I'm myself as a Russian-speaking person, so I know there could be some challenges, especially when dealing with the legal terminology and the legal procedures. So I believe staff can accommodate by having a Russian-speaking and bilingual person to assist and to guide through the application process, so then the tenant is aware of the rights and the policy procedures and what needs to be done, so then there would be no issue, just like today we heard.
Yes, we can
Yes,
definitely
yes.
provide that accommodation. for
Thank
the
you very
tenant.
much. Thank you.
I have one more question. I'm
Sure.
sorry. So did you say, did I overhear you correctly, that in 4998, they dealt with MAR, and that the tenant could go tomorrow and file a reduction in services, and that would be fine for the parking?
For the parking, technically, yes. I don't know if that would be how a hearing examiner would see it, because as we already saw, that already was an issue. So
So
that's
my
why,
point
yeah, go
about
ahead.
that question is that that's what the individual did. The tenant applied for a rent overcharge, maximum allowable rent, and maintenance, and then on the list, removal of 2 parking spots. So how is that different than what you're saying can be done? Because
That is what I'm-
the hearing
That is
examiner
what
did
I'm
not
saying.
agree.
Yes, we're agreeing, I think, but in this case, we don't know. They still didn't do, again, it's procedural. Sorry, it took me a second to get my brain going. They didn't explain that in their application, and that's what the hearing examiner found. So I know it's hyper-technical, but the code and the regulations don't give the benefit of the doubt that an exception applies or that this issue wasn't addressed. And so that's the issue here, is that they're caught up on that.
But and I agree with that. That's what I said in the last case. But we're saying now that had the tenant said, I'm filling this application out, and oh, by the way, the reason I qualify for a 6-month, even though it's not discussed at all, no one's asked the question, no one would have an idea to ask the question, it's the tenant's still responsibility to, when even the hearing examiner didn't bring it up until after the fact? Like, it seems like the hearing examiner is now throwing facts into and making arguments after the fact.
I mean, if you kind of reduce it down to its simplest facts, parking was addressed in 4988.
MAR or
Just
reduction
parking in
rent?
general is what I'm saying. And so that's how they analyzed it. Could it have gone, but I mean, that's why I think we should waive and let them refile. So, I mean, none of this is perfect. And so I think waiving and letting them have that crack at a housing service analysis is the best way to do it, especially if you're going to waive on any of the others as well. Then they can do a fresh application with the assistance of staff.
Commissioner Bass.
Yeah, first of all, thank you. for getting us through. Again, I've said that before, but I just really appreciate how complicated this is, and that there is definitely a sense among this commission and staff collectively to try to make a kind of a bad situation as good as possible. This is probably very obvious, and so I'm going to frame it in the form of a question just to make sure that it's clear. Several times we've said, and I probably said it myself, the tenant could go tomorrow and file. We are in no way suggesting, right, I'm framing it as a question so I'm not providing any advice in any way. We are in no way suggesting that the tenant should file tomorrow. In fact, it might even be in their best interest to seek support to make the best filing as possible, even if that takes a couple of days. I'm framing it as a question so I'm not providing advice.
That is correct.
Thanks.
Okay, Commissioner Copeland?
Thank you, Chair. Sorry, Council, I'm beating you up tonight
Oh,
a
that's
bit.
okay.
But, so if this is waived and a new application is filed, when it comes to the parking, basically, it appears what happens before is the landlord's letter was incorporated into the MAR. However, if this is not something the tenant agreed to, can they, in their application, ask for a loss of service determination, which would basically start that from scratch, and it could go by the valuation guidelines rather than the landlord saying, okay, I'm taking it away and this is what I'm giving you? Would that change that?
I mean,
Instead of just taking another look at incorporating the previous? This would be a new filing.
this would be a new filing under housing service, and
Okay.
The $50 value, could it come into play? I guess the hearing examiner could say yes, but they do not have to go by that.
Or could
they
take a
have the
fresh
guidelines.
look at it and go by the guidelines?
They
Either
should.
one.
They should,
It has that
yes.
discretion. Okay, thank you. That's it for
Yes.
me, I promise. Thank
Yeah,
you, Chair.
That's okay. It was a good, robust discussion.
Chair, sorry to interrupt. I was trying to do research. I shouldn't multitask when I was trying to answer Commissioner Kirby. Is I think part of the reason why, and I know where your question was coming from, I just couldn't get the exact answer there, is on 5029, they checked off all the boxes, and our forms don't say put the item under a certain section. They're just all lumped together, right? And so I think the hearing examiner should have analyzed it as a housing service in this application, but he just kind of lumped it together. I don't even know if he had made the distinction, and not to knock him because this is incredibly complex, but all the boxes are checked off on there, including maximum allowable rent. So because it was reviewed as a maximum allowable rent as to the parking in 4988, it's reasonable, I think, that he said, yes, it had already been reviewed, and so we're not going to review it in this case because all those boxes were checked off. If it was just a request for, maintenance or housing service, that might be different. But all the boxes checked, I can see where his head was at.
Except the hearing examiner says in the decision, these issues should have been brought up with the previous one. Didn't say this is a duplicate of the previous. Says this should have been brought up with the other issues.
Yeah,
So that's why I think it was an error.
I've nothing else on that.
So there's so many issues that just doing this on this one issue isn't going to be that beneficial. So I'll go with what the commission wants to do.
Okay. So I'm going to ask council to lead us in another motion, but basically it's going to be a motion to adopt the resolution, but modify to allow for a new application, to waive the 6-month rule, and to allow for a new application to be filed for the parking issue and the heater issue. And I'm going to ask you to tidy that language up for us in a formal motion, and then we'll ask for a second. I'll adopt, and then we'll ask for a second.
Yes, and to clarify, your request for new language is as to the parking as a housing service and as to the heater
Correct.
waiver.
That's my request for a proposed motion.
Yes, okay. Give me about 30 seconds to tidy this up. and
Take
then-
your time.
Okay, I am ready. So the proposed draft language is in addition to the draft resolution that you have received from staff. The new proposed language is, as to the parking issue and the gas heater issue, the 6-month procedural limitation on filing a new rent adjustment application is waived. The commission notes that the applicant may need to include in their application that the commission has explicitly stated that the frequency of filing limitation shall not apply to the applicant. The commission makes such a finding with this resolution. The commission further finds that the parking space issue was analyzed in D-4988 only as it relates to MAR, as spelled out, maximum allowable rent, and to a potential rent overcharge. The parking space issue was not analyzed in D-4988 as a housing service issue, and any such future application should be reviewed with that finding in mind.
Okay, so that would be my motion to adopt council's proposal. Do we have a second?
I'll second.
Okay, there's a motion and a second, so we'll do a roll call vote.
Commissioner Bass,
Aye.
Commissioner Copeland,
Aye.
Commissioner Kerpies,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Goldman,
Aye.
Chair Rory.
Aye. Okay, great. So that motion passes 7-0. And if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. So thank you very much, Ms. Bella. Yeah, we're going to continue with our meeting, and then afterwards you can chat with him or hang out. But we do have some other items now we're going to move on to, but your part is done. So you can hang out or you can go wherever you'd like, and we're going to continue on with new and unfinished business. Unless anyone needs a break, I think we can try to continue. 9A, which is the announcement of the 2025-2026 annual adjustment to the valuation guidelines. Ms. Avalias, would you please lead us in a report?
Yes, good evening. Section 17.32.020 of the Municipal Code requires annual payment of interest on security deposits, with the Rent Stabilization Commission announcing the applicable rate before September 1st of each year. Regulation 42,000A specifies that the rate is calculated by averaging savings account interest
Hold on,
rates from...
Are we doing 9A or 9B? I think 9A is the AGA.
Oh, I'm so sorry.
That's okay, right?
Yes,
Okay.
you're absolutely right. I
Okay,
apologize.
good, no problem.
In 2021, the Rent Stabilization Commission formed an ad hoc committee to update the valuation guidelines for rent decreases due to loss of housing services or required maintenance. Following 7 meetings and staff consultation, the committee's recommendations were adopted by the Commission in October 2021 and incorporated into the rent stabilization regulations as Regulation 60,041.1 with City Council approval in February of 2022. Regulation 60,041.1 requires that the valuation guidelines be adjusted annually by the Commission's announced general adjustment effective September 1st and rounded to the nearest whole dollar. For the period September 1, 2025 through August 31, 2026, the adjustment is 2.25%, and the updated guidelines will be reflected in the Attachment A and integrated into the regulations. Separately, on April 10th of this year, the Commission voted to consider forming an ad hoc committee to again review the valuation guidelines. The committee was formally established on July 10th, 2025, consisting of 3 commissioners, and is currently working with staff. Recommendations from the ad hoc committee are expected within 6 months, but any changes would require approval by the full Commission and the City Council before taking effect. Thank you.
Okay, so that's the report. I had a quick question, which was just for context and history. Do you remember what the last 2 or 3 years adjustments were? I know this year, coming up in September 1, it's 2.25, but I just, for context, what the previous year adjustments have been.
I believe last year was 3%, and the year before that was 2.25%.
Okay. Any other questions from commissioners? Commissioner Topchin?
Just to follow up on that chair's question, during the COVID pandemic, there were no adjustments, right? Or because there was zero. Clearly.
Right, so we had 0% interest between 2012 and 2021.
Okay, thank you.
The adjustment was 0 for those years.
The AGA was, well, we had AGAs, but we couldn't implement them to the increases.
I see, so they were just suspended, okay.
And just the public knows, these are what hearing examiners use to give them some guidance on if there's a reduction in housing services. This is what they use to kind of give them guidance on a reduction. For example, if a heater or furnace doesn't work, that their valuation would be between $94 and $254, or let's say somebody lost a parking spot, the reduction would be between $86 per parking spot to $324. Is that what the recommendation is?
That is correct.
Just choosing 2 at random, of course.
Okay, Commissioner McCafferty, Commissioner Kerpes? Okay, do we need to do a motion to file and receive, or is that just deemed filed and received?
I think you can declare it.
Deemed.
Deemed, that's my favorite kind of motion. So great, so we can move on to our next item, which is the announcement of the interest rate to be paid on security deposits held during 2025. And staff can lead us to a report on this.
Sure, thank you very much. I'm going to try and be correct on this one, so thank you for your patience. Section 17.32020 of the Municipal Code requires annual payment of interest on security deposits, with the Rent Stabilization Commission announcing the applicable rate before September 1st each year. Regulation 42,000A specifies that the rate is calculated by averaging savings accounts interest rates from the 5 highest yielding FDIC insured online banks with a maximum 500 minimum deposit, as listed on bankrate.com or a similar source, and rounding to the nearest 1/10 of 1%. For 2025, the banks and rates used were Peak Bank at 4.35%, EverBank at 4.30%, Forbright Bank 4.25%, Bread Savings at 4.25%, and Bass Bank at 4.20%. The average rate of 4.270% was calculated, which was rounded to 4.3%, making this the official 2025 security deposit interest rate. Staff recommends that the Commission announce the interest rate to be paid to West Hollywood tenants on security deposits for calendar year 2025.
Okay, great. On this one, what I was going to just confirm, again, for context purposes, we're talking about the interest rate to be paid on security deposits for rent-controlled units. This year, 2024, it was 5%. Last year, it was 5%. 2022, it was 1.7, I believe, and then 2021, it was 0. So that's the context. It's gone from 0, 1.7, 5, 5, and then the one coming up here in September will be 4.3. So a slight downward from the current 5. This is obviously something that has been the subject of discussion in front of this commission. We did have some public comments that were submitted, and they were reviewed, and we appreciate the comments about the methodology. What I would say for the record, though, is as was clarified at our last meeting, this ongoing discussion about methodology was not ever going to affect what happened coming up on September 1st. Those discussions are ongoing, and they will potentially affect what happens for the next rate in September of 2026. So for everyone at home, we understand that there might be thoughts on this 4.3 number, but that's not our discussion tonight. It's really just to talk about the number, any other questions related to the number, thoughts about methodology and process. That's going to be for a future agenda item.
Chair.
Please, Commissioner.
I'd like to ask staff if you've had the opportunity to review the public comment that was provided in writing for this item. I'm sorry. I should have held off. We received written public comment from Mr. Bouchard about this item, and he's testified before, and like the chair said, our methodology is our methodology for this year, and we might consider changing it, we might not, but that's a discussion for another time, not for today. But Mr. Bouchard shared with us that he actually used Everbank as his bank for this last year, and showed us a copy of his statement, and this last year has not been 4.3, but I think I'm trying to look in the actual comments here. I'm not finding it, but I think he said 3.8 this last year. How do we get 4.3 if in reality it was only 3.8? And I'm not a banker, so maybe you need to talk to me like I'm a 2-year-old on this one, because I really don't get that.
Yeah, I have to concede with Chair Rory that this meeting is to discuss or to provide announcement of the current rate. And what we can do is take that comment, that public comment, into account in our investigation and research for how the new methodology, if one is implemented, will be addressed at that point.
No, let me rephrase that. I just want to make sure the numbers are accurate, and I trust staff that. And I actually went to Bankrate and looked these up, and these are not the numbers today, but I know they change every day. So but they looked very much like the numbers that are there today when I looked earlier today. But it's the actual same bank. If it's 3.8, and maybe I need to talk to a banker about why they might advertise 4.3, but it's actually a 3.8. I'm just worried that it's accurate. And so I went to the regulation, the code, and I believe that staff has done this exactly right. But I'm just trying to understand. I'm just trying to understand how we have proof that it was 3.8 for one person. Maybe there's a different account, maybe something like that. But how we would get 4.3 if reality is 3.8. And looks like Commissioner Copeland might even have feedback.
Sorry, I'm tapping myself in the head. Thank you.
Oh.
No, I was going to also say that We did have a lot of public comment, and so we will be discussing this for next year at some point where we can bring up methodology and some of these things. But to your point, Commissioner Bass, when I looked up these banks as well, there was a little disclaimer on the bottom of Peak Bank, Forbright, and Basque Bank that said, their variable rates subject to change at any time without notice, before or after the account is open. So it appears they're allowed to have some fluctuation, which may be, I don't know, could be why that's yesterday 4.20, today 4.15, but it says even after the account's open, that could fluctuate. So maybe when we have our future discussion, we can talk about methodology and factor in those types of things, because what you're telling us now is this is already done for this year. This is just an announcement, but we will be discussing all of this for the next time. Is that correct?
That is correct.
Okay.
So it could have been a point in time, 4.3 is a point in time when staff looked, but when Mr. Bouchard deposited, it was 3.8.
Yeah, they do say subject to change
Okay.
without notice before or after you open the account, so.
And I recognize that any change to that is a conversation for another time. I just wanted to get my head around.
Yeah,
how we
because
got
I had
there.
the same question, so that's why I just,
Thank you.
thank you.
Great minds. Any other questions for staff on this particular item?
I think it would be helpful, though, regardless of, can you reiterate again what the policy is on how we determine, what our policy is on how we determine this rate? I know it pretty much says it here, but can you just say it out loud again?
Sure. So the rate is calculated by averaging savings account interest rates from the 5 highest yielding FDIC insured online banks with a maximum of 500 minimum deposit as listed on bankrate.com or a similar source, and rounding to the nearest 1/10 of 1%.
Thank you.
In August of each year, right? So we look at the August rate numbers.
correct.
And then there's an average. And that's how it's currently done, and that's the announcement for tonight. So with that, I think we're going to do another receive and file on this, and appreciate the report, and that will be what goes into effect for the time being. With that, I believe we can close new and unfinished business and move on to items from staff. If there are any comments or announcements.
I believe it's 9A, the AGA increases to the valuation guidelines that was just discussed. I want to make one small correction. All of the values, and this was Commissioner Topshin's pet project for a while, which I think we all agreed with, that they all needed to go up by $1 at least, because mathematically a low number can never go up unless we have that. That wasn't put into this, so if any of the amounts stay the same, they will be updated by $1.
Okay, that's good to clarify on 9A. Any other thoughts or items from staff?
Not for me.
No? Okay, thank you. We'll do public comment. I don't know if we had anyone to speak.
Not at this time.
No? Okay. Ms. Bella, are you okay?
That's something new that I heard. My dad lives there for 42 years. What happens to his security deposit?
Well, if it's going to be an item for future discussion, so you should stay tuned to our discussions, and you can hear a little bit more about that world.
And I like $80 to $303 parking spot.
Okay. Thank you. Thank you for coming down tonight. We can move on then to items from commissioners. Do any commissioners have comments? Commissioner Bass?
Yeah, I want to thank staff again. In advance, I asked for 4988 and for both of the appeals tonight. I appreciate you providing that. Although it might have complicated things, I think we came to better resolutions because we were able to have a more robust conversation. So thank you for doing that, and just for really walking us through some complicated. I mean, we don't, normally it's whether we look, did the hearing examiner look at the facts and could they come to a reasonable decision? That's something a layperson can do pretty well, but we went into some pretty deep legal arguments, and I just really appreciate that you walked us through that, and my colleagues for entertaining that. and the chair for running a meeting that was pretty compassionate too, considering it was a difficult situation. Lastly, in the appeals tonight, I don't know that it was pertinent to discuss during the appeals, but can staff connect with the tenant, because there were allegations about Airbnb use, which is simply prohibited in rent stabilized units in the city, exclusive, like that's a code enforcement thing. And then also, I believe that there is a law, and I don't know if it's a city law, county law, state law, about the lack of a heater, and that is just against the law, as far as I understand, in addition to being something you can file for a rent stabilization. So that's outside of our purview, but when I hear citizens saying, what do I do about this? I know we have a wonderful code enforcement team whose number I have programmed in my phone, and I just hope that you can connect with them about resolving those issues outside of rent stabilization as well.
We can absolutely do that.
Thank you.
Commissioner Copeland?
I promise this is the last thing I have to say tonight. I just wanted to thank staff so much for all of the legal advice and for the patience and working so well, making our job as easy as it can be up here, and I really appreciate all of you. And my fellow commissioners, it was a good night, robust discussion, and I appreciate it very much. That's it, I promise.
You good? All right. Thank you very much, everyone. This meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on September 11, 2025 in West Hollywood Park, Meeting Room, Council Chambers. Thank you all very much. Good night.
Start with how to thread your needle, how to thread your sewing machine, what the parts of the sewing machine are, and then we walk you through the steps of sewing, which we have on the board, and we go through a training where we're sewing in straight lines. After the third line, then we teach you how to make a seam. It's fun to see certain people take off and pick it up really quick, and then some people that might need a little extra help, a little extra boost, but they all end up at the end with the same product that they all made themselves. First class that we did were gloves, just fingerless gloves.